Good evening, everybody. Welcome to the 2013 Law and the Media Workshop. This is Major Crimes and Mega Trials, reporting on police, criminals, and the courts in the 21st century. My name's Ben Hadaway. I know many of you, and for those who I don't know, I'm a communications officer at the Law Society, and I do media relations here, and I'm going to be the moderator for tonight's event. This workshop is something that the Law Society puts on every year along with the Jack Webster Foundation. Now, the name Jack Webster, I'm sure, is familiar to many of you. He was a long-standing journalist in BC, spent more than 40 years in the business. Less well known about Jack Webster was that he was also one of the first members of the public to serve on the Law Society's Board of Governors. So we include members of the public on our governing board as a way to include the public perspective in everything that we do. And Jack Webster was one of the initial 3 people who was appointed to sit on our board in the late 1980s. Now, you probably know a bit about the Law Society, but just to refresh, we are the legal regulator in British Columbia. We regulate the legal profession in the public interest. We're not here to represent lawyers, and we're not here to represent judges. We don't do the work of government. We're here strictly for the public and to protect the public interest in the administration of justice. A big part of what we do with that public interest mandate is to educate the public about the rule of law, about the role that the Law Society plays in the legal system, and about the role of lawyers. And this workshop is really a part of that public education effort. Now, prior to working at the Law Society, I was a reporter at the CBC. I spent about 8 years as a radio reporter in Ottawa and Vancouver. I always found that one of the most rewarding and challenging assignments was to cover the courts. As you all know, reporters have to work very, very quickly. You have tight deadlines. When you're in court, you have to make sense of what can be very difficult legal arguments, steeped in legalese. You have to cut through all of that and put it back out in your stories. All the while you are doing that, watching out for things like publication bans, or knowing what you can report or shouldn't report at a bail hearing, for instance. And if you're covering a legal story outside of the courtroom, how do you handle things like anonymous sources, or confidential information from people that might want to say things that could be potentially defamatory about somebody that you're reporting on? So those are the kinds of topics that we're going to explore in tonight's seminar. And we have a very experienced panel to help us through with this tonight. We'll start with Dan Burnett. I'm sure many of your newsrooms have worked with Dan at one point or another over the years. He's a media lawyer with Owen Bird Law Corporation, practicing in defamation and media law, and he's taken some of those cases all the way to the Supreme Court of Canada and won. Doriana Temolo, she's the news director at Global National. She's been there for 26 years, and from the looks of it has done just about every role in the newsroom, including reporting, anchoring, producing, and assigning, all the way up to the news director's chair, which is where she sits today. We have Michael Skene, also a media lawyer. He works at Borden, Ladner, Gervais in Vancouver. He's been in the business for more than 20 years, specializing in media law and defamation, setting aside publication bans, and pursuing and defending libel claims. We also have Ros Guggi. She is the deputy editor of the province newspaper, also has a very lengthy history in news. Before working at the province, she worked for the Vancouver Sun, the Globe and Mail, the Ottawa Citizen, and some other papers, and she's won many awards over the course of her career, including Jack Webster Awards. So thank you all for coming out tonight. So without further ado, I'll hand it over to Dan Burnett.
Well, here is our scenario that we're going to unfold and try to tickle a whole bunch of legal issues and learn that way, as opposed to just have a series of talking heads for you. So, Ben, perhaps you can...
Sure, I'll read the press release. So this is April 2nd, 2013. The Vancouver Police Department announces today the arrest of gang leader Tony Brown on weapons, drug trafficking, and organized crime charges following a 2-year investigation. Brown is also charged along with Arnold Venturi in the October 2012 murder of Vancouver police officer Lee Olson. Brown is scheduled to make his first court appearance April 4th, 2013 at Vancouver Provincial Court, 222 Main Street at 9:30 in the morning.
So what we have is a story of a major crime story that goes far beyond just the court beat. It's a story that would I imagine, be a page 1 kind of story that involves the various aspects of the gang and all of that. I want to start by getting Doriana and Ros to just kind of, imagine you're in your first assignment meeting thinking of your angles and your assignments on this, so we can get some threads going, and as we move along, some of those we'll kind of see the legal implications of those. So, Doriana?
I was going to say something flippant about seeing if Tony Brown had ever been with any mayors or had ever mayors' brothers, if he'd ever held any dealings, but I won't say that. Yeah, well, we'd be looking at who is Tony Brown and what's his history. Have we done other stories on him in the past? Any files? What other things can we find out about him? And who can speak about him? And the same on the Arnold Venturi. And on the victim, presumably this murder was a while ago. There must have been a big story. What was the other family reaction and things like that?
And Ros?
Yeah, I would, police officers' family, I think we'd want to see if we could go talk to them, find out what happened. This is a pretty big story. You know, you don't often get somebody charged with the murder of a police officer, and he's also got, obviously, he's a gang leader. So you'd want to find out as much as you can about the background of both of these people who've been charged, and also about the victim's family and the circumstances in which that police officer was murdered. And I would also think that, you know, if it's a murder of a police officer, the police are going to have put extra time and effort into this investigation. So can you find out more about how the investigation, how it broke, like what happened here, who was involved in the investigation, was there a major task force involved? I expect there would have been extra effort put here.
Mm-hmm. Okay, so that just kind of sets a few threads in motion. You've probably got your own ideas about some different angles and perhaps following the bail hearing and so forth. But as the story breaks, here is situation one. It's pretty small for the people in the back of the room, but we've got Global BC's, okay, this is all mocked up by me, but Global BC's Facebook page announcing Tony Brown charged in gangland murder. And maybe can you read some of the comments from some of the readers?
So we've got Leanne Klassen. Tony Brown's reign of terror has ended. Thank you, VPD. From Terry Reels, finally, after all the crimes Brown got away with. And from Beverly Karen, hope Brown gets a cell with Willie Picton.
Mike, do you have thoughts on you know, whether or not a media outlet is responsible for something like this and what you might do?
You know, the standard rules of defamation and contempt would apply to any platform where you're putting up information. So whether or not you're broadcasting it, or you're putting it on the radio, or you're publishing it in the paper, you have to worry about, are you defaming someone? Are you committing a contempt of court? The odd thing about social media, of course, is that it doesn't feel like the other platforms. So when you have a hosted Facebook site like this, there seems to be an assumption from people who are posting information and from a lot of news outlets who are using this to connect with their readers that somehow it's different from the other parts of their business. And there may be something to that. There was a recent case on the civil side where a number of comments that had been posted to a bulletin board with respect to the character of a golf member by other golf members was not able to found a defamation lawsuit on the basis that the judge bought the argument that no one believed these comments on the bulletin board anyway. So they were not capable of being defamatory. And there was also an argument that they were comment. And of course, fair comment has the rules applying to it. Here, though, you have a number of these people that some are making comments which you might be able to defend as fair comment based on the facts that he's been charged. But some go beyond that, convicting him, saying Brown has committed crimes, or on the bottom left, about time for this scumbag. They may be suggesting that he's guilty of it, which arguably could be contempt. You have to decide how you want to manage this risk, and there's different ways to manage it, and we don't have any good case law that I'm aware of that draws a bright line for you. So it's really a matter of risk tolerance until somebody goes too far and there is a case on it, or it doesn't go far enough and there's a case on it and your lawyer is able to protect you from it. Some people, of course, in running these sites would monitor everything that goes up and take down anything that looks problematic. I don't know, maybe a show of hands, does any organization here actually do that with their social media platforms?
We do, but you can't keep up on this.
Right, there's
You wouldn't.
thousands
No,
of comments,
it's too,
right?
we do monitor Facebook, but something like this, it's impossible for
So-
the amount of comments that are coming as fast as you'd have to have more than one person, obviously, and you'd be down at the end and there'd be 50 more at the top.
We tend to, we don't monitor it actively, but if something's drawn to our attention that looks defamatory or looks problematic, then we take it down.
Is defamation at the point of it being published by Leanne Clausen, or is the defamation at the point of being caught with Leanne Clausen's verbiage on the website? Like, if it goes up, is it not automatically defamatory if it's consumed?
Well, it could well be, and that's the risk in even having these types of abilities for people to publish to the world through your facility. The risk is that you may be found legally responsible for everything that's put up there. Now, different news organizations have approached this in different ways. And I'm sorry.
My question is just how much responsibility does Global have for a Facebook page for a comment somebody posts? Because if you think about it, everybody has to sign up, have an account. The commenter would also have their own page as well. So is Global really any more responsible for the commenter's comment wherever they put it on Facebook than the commenter is? And doesn't the responsibility really lie with Facebook?
Yeah, I'll weigh in on that one. We're into kind of flying in the fog a little bit on that area of the law, but most likely what the Canadian courts would do is what the British courts will have done, and that is they've said if you are in the business of hosting somebody else's postings, you are certainly liable at the point where you know about it. I mean, there may be thousands of comments you couldn't keep up, but once it's drawn to your attention, it's your electronic real estate. So whether it's the comment section of your website or your Facebook page or something like that.
Isn't there a distinction between your web page, which you run, and Facebook, which you as a participant participate in? We don't own Facebook. We just sign up and use Facebook as a commenter would.
Well, that would be the argument. I think it would go down. I think once you knew, if you had a clearly defamatory comment, let's say Brian Burke fathered a child, something crazy like that, and it was on your electronic real estate that you could control and take down if you needed to, then there. But there's some other options in terms of dealing with this. Maybe you want to throw me in?
We would not post this story. We try and avoid this kind of story on Facebook because of the comments. On your own site, you can close comments. So, and you see that a lot. You see the Globe all the time, comments are closed for this. So because if it's dicey and potentially a problem, and it's not just legal, we have a lot of stories that invite racist comments that we don't want posted that are, some things, sometimes you can put stories up and you can monitor, but if there's certain stories that seem to be hot button issues that are a little more contentious, and the legal ones like this, if they saw something like that, it's just, you can avoid Facebook. It's not going to go on the Facebook page.
So I think we have one more question down here.
Yeah, hi, just very quickly on the comment moderation comments that you've been making, and the loosely monitoring comments, as in things are drawn to your attention and that's when you take them down. So is it better for an organization to just not have a policy of monitoring, i.e. seeing what goes up, being responsible for what goes up and down in court? Is that a...
There's a huge debate about this. Yeah. And on the one side are the people that say, we're going to moderate and we will follow through on the moderation. And the risk of that is if they fail, they'll probably be held to an even higher standard. People on the other side of the argument, which is probably where I'm at on this, would say, don't moderate your comments, but have a very prominent abuse report structure that anybody can flag for you that comment is for some reason a problem or abuse. And it's very prominent, it's easy. The person who's the subject of it or someone who's offended by a racist comment or anything else easily is clicking a button. It then sends a notification through to somebody that's tasked with immediately following up. Probably that, and again, you know, the technology has gotten ahead of the law, so we can't give you a concrete answer. But in England, that's helped with AOL, that's helped with a couple of defenses. On the civil side, where even terrible things like allegations of production of child pornography and things like that, people have been able to defend themselves by saying, within 24 hours of notification that the material was there, it was off. And of course, it's out there forever, you know, with Wayback Machines and all the rest of it. But they were able to avoid liability in England. And we would argue that the courts in Canada should follow that. Of course, less risky would be to moderate and do it properly, and less risky still would be not allowing these types of comments on Facebook or not. And whether or not it's Facebook or your website, it shouldn't matter so long as you have that element of control over taking it off. If you have an element of control and it's associated with your name, you're at risk of a lawsuit.
Well, we could spend the whole seminar on this one, but this story is just too big. It's moving on. We got to move on, people. So one of the threads that I think Doriana mentioned was you know, let's find out who these people are. I mean, Tony Brown, presumably you kind of know. Who's this Arnold Venturi guy? Is he some junior, you know, gang hack who's following orders and offing people? Do we even have a picture of the guy? So this is a Google image search, which kind of triggers a couple of things. One is to be aware that you know, just because something is on the internet, it isn't up for grabs. Any photo you find, somebody owns the copyright to that photo. Same with video, same with songs, same with. So now in the news business, you've got a very useful provision of the Copyright Act that allows you to use things under something called fair dealing. But even there, you know, if you were to grab a photo and use it, or a video and use it, or a part of it, and it's tied to the news story that you're trying to tell, the provision of the Copyright Act requires credit be given. So of the source, and if known, the owner. So in this case, you'd have a little in brackets, you know, Google Images, and if you knew the owner name on the bottom. So I just want to make that point without dwelling on that side of it too much, so people know. But the other part I want to ask Ros about is just to comment on, and maybe some of you, is this. You know, without embarrassing anybody, I can tell you from my own, you know, legal representation that just about every media outlet in this city, if not every media outlet in this city, has been caught with wrong photo. And it's never wrong photo of, you know, Austin Powers at left just won the lotto. It's always Austin Powers at left just committed, you know, child abuse or murder or something. So it's a big problem, right? And it's easy to do when you're in a world where you see a name. So maybe Ros, you can talk a little bit about that problem.
This area is absolutely fraught, and it's becoming more of a challenge with the need to have pictures up on the web very quickly. You know, we post a story, and you know, you're always trying to get a picture up with the story. And so naturally we go and search Google and we try and find the person. And God help you if it's, you know, an axe, you're saying this person's an axe murderer and they're actually an upstanding citizen. It can be a nightmare. And so I think you need to really take care with anything that you're finding on the internet. You want to find, you know, if you see a picture of Arnold Venturi here and you can find 5 or 6 or 7 references to him, that gives you some comfort, right, with that clearly he looks like the same person. But even better, and I think ideally, in an ideal world, you would have a visual confirmation of this person. So maybe you've got a reporter who's been in court who has actually seen this person, or you can call a police officer, you know, who's a friendly, and maybe send them, you know, email the photo to them and just try and get a confirmation, an absolute confirmation that this, in fact, is the man charged with murder. Right, and if you don't, yeah, you can run into some difficulties. And I think, as Dan said, all of us have faced situations where we wish we hadn't run that photo. So.
Yeah, and there's been at least, well, there's been one case that's gone right to a judgment. Even despite a big apology, wrong photo led to, I think it was a $35,000 award against a Vancouver media outlet. So that's what you're talking about.
Oh, I was just gonna ask about the like the Bowen Island case. So was it the Bowen Island paper?
I was referring to a different one, but is there? Do tell.
I believe it was that. I don't know. I read like the judgment sometime in the last year, and I think a reporter I don't even remember what, it was a community paper, maybe it was up in Seashelt, I don't know, but they gone to court and had published a thing, and I don't remember what the charges were about, but they ended up running a photo of like the father or the son instead of the father, something like that, because they had the same name. The reporter couldn't tell the difference, and they had this photo on file, and so it was like a defamation kind of suit against this guy's reputation.
Yeah, and it's not the first. I mean, there's only the one that I know of that's gone all the way to a trial and a judgment, because, I mean, how do you defend something like that, right? So these things tend to resolve themselves, but it's not a very happy situation. Maybe I'll move on to the next event in this story, and maybe Ben, you can help out with this.
Yeah, so we're on our bail hearing now, 2 days after the news release went out. So from the criminal code, the evidence taken, the information given, or the representations made, and the reasons, if any, given or to be given by the justice, shall not be published in any document or broadcast or transmitted in any way before such time as A, if a preliminary inquiry is held, the accused in respect of whom the proceedings are held is discharged, or B, if the accused in respect of whom the proceedings are held is tried or ordered to stand trial, the trial has ended. So maybe if we can ask Michael just to explain bail hearings, what can you report, what can't you report, what do you have to watch out for?
Sure thing, and the next slide actually has a bit of context for the story. But everyone in the room looks pretty experienced to me, so you're familiar that there's a federal statute, the criminal code, that sets out this ban that if you breach it, you would be in contempt of court and subject to prosecution, perhaps imprisonment, more likely a fine, if you breach the order that's made under 517(1). Now, at a bail hearing, the challenging part is there's all this great information that comes out from the Crown about why this accused should never be let out because it's such a disaster. And a lot of that evidence, some of that evidence, may never be admissible at trial. And of course, there might be some character or exculpatory evidence about why he should be granted bail. So there's lots of interesting information that you collect at this, and you wonder, when can I use it? And it's very clear that you're not to use it until either the proceedings result in a discharge of the accused, so he or she is out, or the end of his or her trial. And the theory is that that prejudicial information that may never get in front of a jury, which is unlikely anyway, but that's the way the rule's set up, won't prejudice that person's fair trial. So you have this context here, which is a mock-up of CKNW's right on the money reporting. So Brown was denied bail.
Actually, maybe some people can in the back can hear it. We can read this one out.
So Tony Brown denied bail. Accused murderer and gang leader Tony Brown was denied bail in a ruckus courtroom today. Brown supporters wearing gang jackets were ejected from the courtroom for disturbing the hearing after yelling, "We got your back, TB." Brown glanced at his family in the gallery but otherwise showed no emotion as he was taken to lockup after bail was denied.
Now that's writing. So, anyways, so I mean, so I'm interested in Mike's comments on can you say he was denied bail when you got this ban in place? Can you say these things happened in the courtroom?
So let's flip back to what the rule says. Now, if you're a Crown lawyer, you'll have one view on this, and if you're a media lawyer, you'll have another view. And of course, we're right. But the Crown might try and tell you, hey, you can't go reporting anything that happened in the courtroom because that's information. You know, whether or not there was a ruckus, whether or not supporters were ejected, whether or not he showed emotion, that's information from the bail hearing. A media lawyer, I think Dan is with me on this, I think every media lawyer I can think of would say, no. The ban is on the submissions that were made, so the evidence that was led in front of the judge, the representations that are made, and then if bail is denied or granted, the reasons. I'm not going to let him out because none of that can be reported. But the fact he's been denied bail can always be reported. And if he's granted bail, let's say he with these criminals, but if he's granted bail, the bail conditions, just the straight vanilla conditions can be reported. But your media advisor, legal advisor would say, look, information that you gained in and about the courthouse or in the courtroom, such as there was a ruckus, an ejection, you're not going to be charged. You're not going to be successfully convicted for contempt on that. And if you wanted to be as conservative as possible, you wouldn't report anything about it. But I think most of us would say everything, if we go back to the story, the raucous courtroom would be fine, the ejected would be fine. Now, showing no emotion, I paused for a moment, because does that tend to suggest that he's a sociopath or guilty? And then I overcame that and said, no, it just showed no emotion. But it did cause me to pause a little bit. My advice on this is that everything in it is okay. If you went further and said, he looked like a sociopath or he looked guilty, right? Then we're going down.
Observers said.
Then the observers thought he looked like he was guilty of some things. Then you have a contempt problem, right? So are you the same?
Yeah, no, I totally agree. Good job, NW. Okay, let's move on. Now we have an email to Doriana with a photograph of a gated fancy residence, and the email says, it's from Tim, whoever that is. Doriana, this is as close as I could get to Brown's house for a visual. I can try sneaking through some side trees, or maybe there's another option. How should I handle it? So that's what a news director gets to do, is to pull reporters off the edge of the cliff sometimes, or maybe push them over. I don't know. You go ahead.
Well, I would say it's common sense. You come to the gate. Is the gate locked? Totally locked? Then you ring a bell. Ask if they'll let you in. You never know. It's happened in the past where they weren't sure who they were letting in, paperboy or whatever, and you can then go to the front door. If the gate is not locked, I would open it. I would go to the front door. I would go rolling and knock on the door. It could be Mr. Duffy's house, and then you'd be told to leave. They'll call the cops. That's what they've been doing. But that's normal, I think, and proper, and it's respectful, and you're going about the normal way. Now, once you're told to leave, you've been told to leave. I would not expect my reporter to be in the bushes, as again Rob Ford says some reporters have been doing, waiting to ambush them as they're leaving. But those kinds of things are, I believe, permissible. That it's the normal expectation. You go. Maybe they want to talk. You never know. And they don't, you leave. And I wouldn't hop a fence. Now, if you can see, if there's an area down and you can see from, when you're outside, it's public property, you can be shooting at the house. I'm thinking of Conrad Black, who, when he returned back from Florida, when he was released from prison, all the reporters were in the back gate. His wife did not want to come, Barbara did not want to come to the fence, but the dogs came, so she had to go get the dogs, and then she talked to reporters. It was a clear shot, everybody got it. I wouldn't, it was a fence you could have hopped, but we're not into trespassing.
Well, yeah, there's the ethical, not being slimy journalist side of things, and there's also the legal side where an enclosed property falls into the category of being something that one cannot trespass. A gate that's unlocked with a walkway to a door is an invitation until you're told to leave. Yeah. But something that is as secure as this would certainly qualify as something that you wouldn't you'd be committing trespassing by sneaking on. But there's an even more creative option. Maybe I'll get Ros and then you to comment on, yes. Which is in the did you know about this category. And I'm not joking, this is happening. A radio-controlled helicopter drone with an onboard camera. What a cheap way to get images without hiring Chopper 9 or whatever it is. And it's obviously raising some issues. But before I talk about that, maybe you have a thought, Ros?
I had never seen this before. I was flabbergasted when you sent it to me, and I honestly don't know what to do with it. It's kind of, it's a little bit, the Google trucks that go around and are taking pictures of everyone's front, but this takes it a big step further. So I don't know. We'd have to have, I think, some discussion in terms of, what would you do with this? Yeah.
If I may, I've actually fully looked into this.
Oh, you have? Wow.
If a remote-controlled aerial vehicle is used in a business case or in a business model for the gathering of footage or for publicity or anything along those lines, it falls under the auspices of Transport Canada, and a flight plan must be both filed and approved before you can fly even a little remote control helicopter, because that's way cheaper than Chopper 9. And you could have one of those in every news truck quite easily for a fraction of the cost and be gathering video. But the second you put a brand on it or put a corporate name beside it, it's no longer recreational personal use. It's now business use, and it falls under Transport Canada, not allowed in Canada.
Well, you mentioned what I was going to get to, but while you've got the mic, I want to ask you this: would you send it up rogue for 5 minutes to get an overhead Stanley Cup riot shot?
The challenge with that is it's great, it's perfect if you get the shot and you land it safely. If you slam it into the side of a kid and he's bleeding on the side of the sidewalk and it's not the result of the riot but your little helicopter, I got way too many.
And you put your sticker on it?
Too many lawyers in Toronto that would be unhappy with that. So,
one possibility would be someone else brought you the images that they obtained with their own private drone, and that would be a very interesting ethical discussion, because now it's a freelancer who just happens to be selling killer video that they obtained with their own drone. And in that situation, I think you just have to look at it ethically. You know, we're members of the community, and how do we want to conduct our business? So if it doesn't pass the sneaky test, then we probably wouldn't use it. But if it had news value, I think you'd have to look at it pretty seriously.
Is there a question over here?
No, I was going to say, actually, what do you call it, the BMO marathon? There was actually one flying over the, what do you call it, at QE Park, where everybody was lined up. There was actually somebody on the lawn with one. They had it up in the air, and they were flying it back and forth, taking pictures of all the marathoners and half marathoners that were lined up ready to go. So they are in Vancouver.
Yeah, so it raises some issues. It raises some privacy issues, right? I mean, you fly it over, you look into somebody's window, you know, so but be aware of the Transport Canada issues that arise. Don't just rush out to Radio Shack, buy yours, and start reporting with it tomorrow. But having said that, and being aware of some of the sort of potentials for abuse, one can imagine some potentials for some very serious news stories where you couldn't get the visual any other way, you know, it would be an option to be thinking about, and I know there's talk about you know, whether the Transport Canada rules you know, need to alter and below certain levels and things like that, but one to watch. Okay, where are we now? We're going to move to, oh yes, Lloyd.
Yeah, so we've got Lloyd here reporting on this story. Friend of co-accused Arnold Venturi says Venturi, quote, was an underling who felt he had to carry out orders. When Brown gave him an order, he knew he had to do it or die. So a pretty serious statement there. Maybe we'll ask Michael, do you see any legal problems with that?
Yeah, I mean, you know, it depends. This is pretty clearly a contempt, right? I mean, what you've got here is you're saying Venturi was an underling, which implies, I think, that he was part of a criminal conspiracy. You imply that Brown was a crime boss who had an underling, and then you also are pretty clearly suggesting that Brown threatened to kill Venturi. So you've got a lot of contempt going on in here. Now, not being a Crown lawyer, being a media lawyer, I know we would then say something like, this is contempt, it's really risky, but if it's really, really an important news story, I don't know that this would be an important news story, and an important part of the story, you go to the second part of the analysis, which is how far away is the trial? If the trial's 2 or 3 years away, this is nice and fresh. The trial's a long way off. Maybe you throw in a nice motherhood statement that he's never been convicted of anything, so you have a bane and antidote defense on the defamation side. And the story as a whole is not a contempt because it's just reporting what this guy said, and then it's making clear that we're not saying that he's a convicted crime boss. And then you would do a risk analysis and you'd say, is it a manageable risk or not? And you can get into these sorts of discussions. But I think it's pretty clearly a contempt. And then depending on how important the story is, you then have a discussion about are you willing to run the risk of ever being prosecuted and then being convicted for contempt? And I don't know if that's too aggressive, but Dan, you along those lines, or?
Yeah, I mean, if I was presented with this particular quote, I would be asking the reporter, you know, could you go back over your tape and find you know, a still good newsworthy quote, such as he was just a young guy who has, you know, gotten himself over his head, something that doesn't make him guilty or anybody else guilty, but that nevertheless kind of tells the story. And so, you know, one of the lessons that I try to instill in journalists is, you know, to kind of spot these things. And I want to spend a moment just talking about how you spot a contempt, but to spot these things, and if you do, kind of keep them talking and kind of recognize that, you know what, that was a fantastic quote, but, you know, Skene's never going to let it through, and neither will Burnett. And so, you know, we're going to, you know, we should try to get some more here, that we're going to have to give ourselves some options. You know, in terms of, I think, spotting what is a contempt of court, we're going to have another slide that kind of tickles another side of that in a moment, is one of the toughest issues, because it's what, I mean, the test is, what would materially influence a jury in a criminal case? Okay, so if you've got a case before the courts, a criminal case that is, and some information that comes out, it's like, well, Willie Picton's a weirdo. You know, okay, but is that going to really influence a jury that he's a murderer? No, there's a lot of weirdos who aren't murderers, right? But you know, see, it's how far do you go along the path? And one of the tests that I kind of encourage people to think about is, if you were a member of the jury and you remembered this news story, would it make you think this guy's guilty, or would it just be, well, that's just some more information? So that's usually a pretty good acid test to apply on this part of it. Ros or Doriana, do you have thoughts about the newsworthiness or how you'd handle a situation if you got a quote like this and what you'd look for?
Well, does he have an axe to grind? I mean, friend of co-accused, he's in silhouette, he's not identified.
Yeah.
Who's going to know who he is? Is this some guy that, I don't know, he stole his girlfriend and he wants to get back at him? I'd have a lot of concerns.
So is it even reliable?
Yeah, that was my...
I would have concerns with this one too.
Yeah.
Further to convicting people before they get to court, what are your thoughts on calling people gangsters or gang members in advance of them going to trial? You know, everybody knows that Jamie Bacon is a gangster, but do we want to be calling him that, or are we calling him an accused gangster, an accused gang leader?
Yeah, that's, you know, I've struggled with that specific question a few times, and my take on it is that there are times when a person is so clearly and publicly a gang leader and proud of it, that, you know, calling them a gang leader is not a controversial statement. It's interesting with the phraseology, gangster. You know, I mean, at that point you're saying more that they're a criminal than they are a leader of the. In this case, we're calling it the Red Lobsters. It has nothing to do with this scenario. Has nothing whatsoever to do with Jamie Bacon people.
I thought it was the restaurant.
That's right. That's right. That's where they meet. Yeah, well, Bindi Johal, another one. I mean, it's almost like celebrity gang leader. But you know, I've had situations where I've changed language from gangster to you know, prominent gang member or gang leader, and other situations where you're not even really sure if the person is a member of a known and pretty notorious criminal gang. You know, whether they're a Hell's Angel, whether they're, you know, a member of the Scorpions and so you need to be a bit cautious there in terms of just knowing your facts. But when you've got somebody who's a leader in that situation, be a little bit careful about the terminology. And the other part of it, we've gotten sort of used to the Jamie Bacon situation because, you know, there's already been at least some criminal conviction in the past, right?
Assuming for a second that these people are not proud gangsters, you're doing the contempt test, and you touched on the question of defamation, but wouldn't you also do a contempt test and a defamation test at the same time?
Yes. Yeah, and it's really easy to get caught into the mindset of my issue here is contempt, and once I solve that, I'm golden. And you got to be really careful. Or the issue here is publication ban, and I'm okay on that without thinking through the contempt. Like you're thinking through all these things at the same time, right?
Because the accused, they might be busy right now, but they might see your coverage and they might feel like suing.
Yeah, and it's
right?
happened where somebody quite notorious has nevertheless decided to commence defamation action. Sometimes the most surprising people, you think, well, that person will never sue, and they do. So it's a really good point to make.
Does it shift a decision when the police, in a press release or in a statement, name someone as a known gang member or known associate of this gang, or should that affect, like, do you just take the police's word for it?
Maybe I'll ask Doriana about that first, then Mike, because there's a reliability aspect and then there's also a legal aspect, right?
Well, I guess we'd be looking to see why they're saying that. I mean, that probably would be asked, and I would think most times it's because they have priors. That's where it comes from, and my feeling is we'd probably say police say, but so you put the onus on them. But if police are saying that publicly, I would be comfortable probably going with that.
Yeah, I mean, it's helpful, but it's not conclusive. So if you are sued in defamation or if you are in contempt, the fact that the police led you astray to getting that point might help you when your lawyer is groveling before the judge, but it's not going to be a get-out-of-jail-free card, put it that way.
I think you'd want to ask, though, why they're saying that first, and if you're satisfied with their answers.
An interesting example was when who was the accused? There was the tape of sex videos found down in Crab Park, I think it was. Baker. Mm-hmm. And the police press release was remarkable. The police officer said, in 30 years on the force, I've never seen anything so disgusting as what I saw this guy doing to people on this tape, or words to that effect. Which the police officer's statement that got everybody reported resulted in, I think the case didn't go away on this basis, but there was eventually a mistrial application based upon that statement by the police officer. So, you do have to keep your wits about you and just don't be on autopilot and assume that anything they say is fair game, because they might get carried away.
But isn't that fair comment, though, if a police officer says, I've never seen anything that disgusting in my life?
By this man, though. I think that's the key.
The language was extremely pointed that this man was committing horrible, horrible acts on this tape, like he's guilty, basically.
I think if you quote the police officer saying, I've never seen such horrific acts on tape ever, that's different, right? As opposed to saying, this guy did it. Mm-hmm. Yeah.
So here we have a text message from reporter Sam in the field to Ros. It says, Ros, I just made contact with a guy who Tony Brown kicked out of the Red Lobsters gang. He knows all the inside stuff, but will only talk if we absolutely protect his identity. What do you say?
Okay, so anonymous sources always make me uncomfortable. And I think the reader doesn't know who this person is. The reader can't judge whether this person has an axe to grind. The reader can't judge the person's credibility and where he's coming from. But there are cases where you cannot get the information any other way. I would be very careful in terms of an absolute promise to protect identity. I'd want to know, first of all, as the editor, who is this person? I'd want Sam to tell me who's the guy who's offering to give us information. What can you tell me about him? Make some kind of assessment of, whether I think he's got some credibility. We have a rule at the province that if it's an anonymous source, a senior editor needs to know the name. We'd be under the same promise that the reporter makes, but we need to know who it is who's giving us the information. There are some cases, many cases, that we can't get information unless we have anonymous sources. Liberal sponsorship scandal, the recent Ethnic Gate scandal in BC, and Mayor Ford. My God, there's many journalistic stories that have come out because of anonymous sources. So you have to judge, I think, public interest. Is this something you can get corroborated by someone else? But in terms of the promise that you make to this source, I think you can say that you will try and protect his identity as far as you are legally able. You would even fight in court to protect it, but if you're faced with a court order, it's either jail or you're going to have to give it up, and you're probably going to give it up, right? I don't know, you'd have to really think, are you willing to go to jail to protect this source? I know with one of our reporters, Dan has been quite successful in allowing us to protect the confidentiality of a source. It's gone all the way to the BC Court of Appeal after an earlier judge ruled, it was Elaine O'Connor, and she promised confidentiality, and she said, I'm not going to give this up. And so we've spent a lot of time in court defending her right to keep that source anonymous. In this case, there are a lot of judgments you'd have to make. First of all, about the credibility of this source, and then if you do promise to protect this person's identity, one of the things you might think about is using a code word in the notes. Your notes could be demanded by the police. And so, if you've got subject X or whatever, the name of the person might be in your notes. That's one way the police are going to get it. So if you make the promise, you have to take it fairly seriously. The other thing I like to do if we get something from an anonymous source, and I think is necessary to try to do, is to corroborate that information independently with someone else, because the person in this case is probably fairly shady himself. I'm just guessing, so yeah.
Yeah, those are excellent points all around. Do you have some thoughts too, Doriana?
No, just further to what Ros said about what they tell you. Perhaps they'll give you information that you can then find through other sources, something that you didn't know, and you can find two other sources that can tell you and will go on camera perhaps, or there's documentation about some of the stuff they mentioned that you had no idea about. So that's another reason that they can be very helpful.
Mm-hmm. And is there some legal key points, Mike, to bear in mind on?
I think Ros and Doriana have covered most of the legal points. All that I would add, though, is if the decision is taken editorial to promise as far as you can the protection of the identity, it would be very good to record very carefully or document the words used to make that promise, because then when you get Dan or me or somebody else in to go fight about it, you're able to say to the judge, this was the promise, as opposed to the reporter having to give that evidence in an affidavit. Well, I remember saying this or that. The judge will be much more impressed with, I think, the language and having the precision of the language documented. I think it's particularly important for more junior reporters to be aware in Canada that there is no protection here. I mean, Dan can do his best, and you might get a sympathetic judge, but at the end of the day, if it's viewed by the judge, there's a compelling reason to make the order requiring you to divulge your source, you have to divulge your source. There's no statutory protection, unlike in the States, and your choice would be contempt, jail time, a big fine that could keep going on until you purge your contempt by revealing the source. So there is no protection at the end of the day. And the only other sort of practical thing I would think about is, where there's a story like this, and your reporter and the editor becomes aware of the identity of this witness, essentially, whether or not the reporter and the editor are now at risk, at some heightened risk from the gangsters. If you end up reporting into the story and they think, oh, well, he knows where Joey is, let's start following the reporter around, or the editor, or let's kidnap the reporter or the editor, right? I mean, I haven't seen this happen, but it's certainly, if I was a manager, I would start worrying about these things in a way. The day before the story, I wasn't worried about it. And the other possible ramification down, I just remember there was a story, we had talked to somebody in Picton, or the reporter had, and there was all this great stuff, and when could we use it, and that sort of thing. And we were really concerned about committing a contempt by interfering with the witness in a criminal prosecution. So just by the very fact of having talked to this person and documented his evidence, whether or not that could put you on the wrong side of a witness tampering allegation, which they would then bring as an extra pressure point on you. So you're quite right. These things are last resort, dangerous, fraught with angst, all the rest of it. Only when really, really, really necessary, I would think.
There's there are shield laws, I think, in 49 U.S. states, and there's a renewed push there for a federal media shield law. And I found this interesting quote from a South Carolina senator. He told reporters, "As much as I hate y'all, I think you should do your jobs. You should be able to be the annoyance you are." So, you know, there's a lot more legal protection in the states than we have here.
Just quickly, and just to go on the hypothetical, because I've run into this one before where, yes, we will protect your identity, and then they implicate themselves in the actual crime. And now, what is your legal obligation at that point where they might implicate themselves and tell you things that they should stand accused with Venturi and Brown? And there's a whole side of ethical consideration that has to go into that. But legally, is a reporter then obligated at some point to cough it up?
Generally not. Generally, that would be the police to uncover and get to the bottom of. And one way they might do that, as soon as they are aware that you've spoken to the person, they might subpoena your tapes. So whenever you're dealing with a source like this, you'd be aware that that could happen.
What about
but if you've got a situation where a person is saying, well, you know, I'm going to be carrying out a hit next week on so and so.
That was my next question: is if there's imminent harm?
Yeah, then you're into you got to act on it. I think, you know, I mean, if you think it's a serious situation. Okay, I know we can go on and on with this one, but story's too big. Draft script. Want to give a read and.
So we start with our sound up. I mostly feel bad for mom and dad. Tony Brown's brother David spoke exclusively to CTV. Tells a story of a brother who got in with a bad crowd in school, and now the high-profile gangster is the shame of the family. So we have our clip of David Brown. He had a long juvie record before grade 11, then dropped out and went straight into the drug trade. It's all about money and machismo with him. Tony Brown's criminal charges show an escalation from petty crimes to violence as the years passed, but his only conviction was for assault in 2009, and then out comes the criminal rap sheet visuals.
Okay, I'll pull that up, the sheet in a moment. Mike, what are your thoughts on you're given this draft script to vet for CTV. There's a likely scenario. And what's your advice? I mean, hypothetically.
Well, it's exclusive, so. Yeah, there's not much good about this script, right? I mean, the juvie record, everyone knows is a no-no. There's lots in here that convicts him. There's lots in here that defames him. The escalation to violence, the reporting of a prior conviction is clearly a contempt. So pretty much everything in this story is contemptuous. I don't imagine they would run this in this form, and I'm not sure that they could save it. And the same analysis as before, if it was really, really important and the trial was a long way off. But even then, reporting a prior conviction in these sorts of circumstances, I think you would face a contempt proceeding. And our advice would be, this would be a very perilous story to tell in anything like this kind of a format.
If you knew that you were early on in the process and it was a good year and a half to trial, would the 2009 assault conviction have a bit more wiggle room?
Generally, the ones that we're quite comfortable going with is where the prior has some newsworthiness, like it was multiple DUI convictions in the past, and then the guy mows down the 2-year-old or the 3-year-old. And so the real story is, why is this guy out and about? Why wasn't he more adequately punished before? Or why is he out on bail is sometimes an important part of the story. But here it's just a gratuitous sideswipe about him being a bad guy. I'd like to hear whoever wants to tell this story's pitch for it, but I'm not sure that there's a public interest in those facts that outweighs the risk of the story.
So we have a question down here.
Well, you touched on it there, but I mean, in my experience, when we do a story, anything close to this, the first thing we do is look to see their history in the courts. And without fail, we report it, every detail of it. So I was just surprised to hear you say that you think that's fraught with peril, yet I hear that every day, without fail.
Well, I can weigh in on that a little bit. And it's it's an area that is of greater debate than I think many of us think, just in terms of the day-to-day. I'd say 15 years ago, it was a textbook contempt to report a criminal record, even at the earliest stage. Starting within the last decade or so, there's been a very small number of court decisions that come out that have not sort of in a direct, you could hang your hat on it way, but in an inferential way have suggested that at a very early stage, at the very early stage, a prior conviction would not amount to a contempt, because it would not amount to something that would be so irreparably damaging to the fair trial. And for example, Prince George, editor there, got dinged with a fine and conviction for contempt because he reported in an editorial a conviction that was very shortly before the trial. One of his arguments in defense was, well, wait a minute, the Vancouver Sun also reported this, and the judge said in the judgment, it's one thing to report it 14 months ago, it's another thing to be saying so now. So that kind of inferentially supports what you're saying. Translate that, however, and so I tend to be a little bit aggressive on that, and I would tend to be fine with a very early stage reporting of this particular conviction. However, let's say it's a web report as opposed to just on the paper today and under the birds tomorrow. It stays there, right? So if you're going to report on the early stage, you need to be live to the fact that if your report's going to sit there and become a topic of greater interest as the trial gets closer, and your website has auto links that refreshes that story and puts a link up to the most recent story as the trial's approaching, you got a problem. So you need to be live and fix that.
But even if you delete it on yours, so you don't link it any further on your own site as you get closer to trial, it's out there. Anyone can access an old story if it's been resent and moved around, right?
Well, I mean, like on your archive.
Yeah.
I mean, it's a question of how deep you keep your archives and how prominent. And I've had the debate about, do you remove the thing later, or do you just simply not? If somebody is dedicated enough to search it out. I mean, the truth is, if they're dedicated enough to search it out, they can. And I'll go to the next slide. They, along with anybody in this room, can go to Court Services Online and plug in the guy's name and look up his criminal record. So my view of it is, if your news archive makes it no more difficult, no more easy, I guess, to get than you could from the government site, then what's the problem? So this is, for those who, I'm sure many of you already use Court Services Online, but if you don't, it's an incredible resource where you can plug in somebody's name, and you better be careful that you might get somebody with the same name, right? But plug in somebody's name, you can get their criminal background. There's all these little codes. It refers to assault 2009, and then it has a G, and there's a little sheet you can print off from there which has all the code. G means guilty, obviously. But you can also do it with civil proceedings. You can plug in somebody's name and see not only what civil suits they've been named in the last 15 years or so anywhere in the province, but if it's relatively recent, like within the last 5 or 8 years, you can usually see the court documents. Like when the Brian Burke story about being able to serve the lawsuit on the web boards came out today. I was able to go onto CSO, and in 2 minutes I had the court motion that was the basis of his argument up in front of me, and so that's an incredibly valuable thing to be able to do. Usually at free search, and then if you want to look into a file, it's $6 a pop. Question down front, if there's a microphone.
I have a question about the prior convictions and that. What if what do you call it, you do research the court record and you find that he's had, say, summary offenses or something like that. You know, on the example you gave us, it was assault, which is violence, and you can sort of see that's in the same bailiwick as what he's, you know, sort of charged with in that. But what happens if he has a record that points to other things that may not directly link to the crime here? And that, can you report them, or what is the risk of reporting them?
Well, in a way, there's kind of a paradox. On one hand, the more similar the record is, the more newsworthy and relevant it is. On the other hand, it's also the more prejudicial, right? Like if somebody's, okay, they've got a, you know, whatever, you know, they had their possession of marijuana 5 years ago. Well, that doesn't really make them a murderer. But it's also not very relevant to the news story, so it kind of gets into the point Mike was making. You get somebody who's actually been convicted of murder 3 times before. That's extremely relevant, but it's also extremely prejudicial, and you're really sending a message to the potential jurors out there. So, so it's a matter of it's really a case by case. I hate to cop out with that kind of answer, but you really need to look at the array of information, and sometimes it can depend on, you know, you can have a small town situation too, right, where you know, the only story, big crime story in that town is the one is this one, let's say. And it's not as though it's the big city where there's a million cases going on and people forget. There's nobody in that town where the jury's going to come from that's going to forget some of the reports. So I urge generally more caution in smaller towns. Maybe one more and then we'll move along.
I was just wondering then, if you're looking at risk management, how aggressive is the Crown on contempt? How many contempt actions were brought against media in BC last year, for instance? How often is this happening?
I'll be interested in Mike's answer to that, but mine is that and it maybe goes to this issue about the criminal record. Criminal records reported at the earliest possible stage in a proceeding, in my experience, have resulted in zero prosecutions. So that says something. The contempt proceedings that have happened, you know, there's actually been a nice lack of them for the last, I'd say, couple of years.
Zero?
One that went away. So but you know, that's been maybe hopefully a sign of the future. I would say you get within Vancouver a couple a year prior to that, and for a big long period of time, most of them were identifying an undercover police officer, like using the name they use in court, which by the way is their real name, and you know, they do that so that, you know, when somebody says their real name, they don't look this way and then get shot in the head. So, you know, that people will become more educated on that. I think Crown has backed off a little bit, but the last really, you know, contempt for reporting somebody's criminal record, probably 5-6 years ago, and you know, and it was a pretty obvious one right on the eve of trial. So, and there's been a couple up country. Prince George seems to be a bit of a, you know, for a smaller place, they seem to get one a year just by themselves. So. Okay, anyways, let's move. This one's a bit of a shorter, but maybe let me.
Sure. So, Vancouver Sun story here. Tell-all book could derail the Brown trial. David Brown's lawyers are making a bid for a mistrial after a book about Brown and his gang hit the shelves last week. Defense counsel told court that the book contains confidential and inflammatory leaked wiretap transcripts. Arguments have been set for next week, and the book publisher, Doubleday, has been served with notice to appear and face possible charges. And I guess we have a picture on the left there of Brown and his former girlfriend.
So, I mean, this was a bit of a short snapper, but one of the things that happens sometimes is, and has happened in the Bacon case, the completely unrelated Bacon case to this scenario, is that there was a leak of confidential Crown disclosure documents at one point, and I thought it was interesting that you know, every media outlet that I saw immediately realized that it might be available there on the internet if you know where to go, but not one of them took the bait and reported it, even though you could argue, say, well, it's out there. So you know, the report is about this incident happening, but without, you know, getting into the actual material that could cause a contempt or a mistrial. I mean, part of this is, we've talked about contempt and your own liability, defamation, all that, but when you're dealing with a criminal case, one bigger picture item to be aware of is you do not want to be responsible for a mistrial in a great big criminal prosecution, right? I mean, just aside from liability and getting convicted and being embarrassed, it's, that's just as a matter of the public good, that's public bad. So unless somebody wants to comment on that one, I'll move on to the next, because I need to catch up a little bit on my timeline here. Okay, News 1130. What do you need help up with this?
All right, so parents of Tony Brown under fire for son's lifestyle. News 1130. Neighbors are raising questions about how involved Jim and Tammy Brown may be in their son's gangster lifestyle. Tony Brown and his pals are constantly at Jim and Tammy's place, wearing their gang jackets, drinking and smoking dope in the backyard. Everyone in the neighborhood is scared to let their kids play outside, said one unnamed neighbor. Other neighbors are asking questions about the expensive Jaguar car the parents are driving. Quote, he's a teacher and she doesn't work. How do they afford that? I'm guessing it's their son's drug money.
Cleverly disguised.
Good one, 1130. Okay. I actually, before I get Mike to weigh in on this one and rain on the party, I want Doriana and Ros to give me their thoughts.
Pretty obvious. There's a lot of problems. I mean, you could say they're constantly in the backyard, I guess wearing their gang jackets. Drinking, that's legal. Smoking dope, no. So I wouldn't allow that to go. I thought about everyone in the neighborhood scared to let their kids play outside. I could see that being, I could see that being valid if you, depending on what you put against it. But if that's what you feel like with these people in your neighborhood, and I think this does sound a little similar to the Bacons. As for the expensive Jaguar car the parents are driving, I think you can have people say, how do they afford that? Look at what they do for a living. I think that is a potential question. What you can't have is have them say, well, I guess it's their son's drug money. I think that's the problem. I think it's, I would seek legal opinion, of course, on this, but I think it can be phrased in a way as saying, this is what these people, this is their income, potentially, this is what they do for a living, and here's how they live. You draw your own conclusions without you saying that.
Yeah, I would totally agree. I was concerned with, I'm guessing it's their son's drug money. I think you can, how do they afford that? I mean, everyone knows you don't have to be explicit, and the, smoking dope, but the rest of it I think is legitimate and probably defensible, but you can tell us.
And before I turn it to Mike, it really ties into the question earlier, which is, this one is a bit of a mixture. You've got defamation issues of the parents, you've got contempt issues about Brown, who's facing this trial, and now you've got him, in the backyard smoking dope and maybe having drug money and so forth. So,
yeah, I think most media lawyers try and advise what's the most you can get out, right, with the least risk, as opposed to killing anything and the rest of it. So looking at this, your lawyer is going to say, oh, really, do we have to do this? And then they'll go through it line by line. On the contempt side, I guess your only real risk is this whole thing about the son's drug money, which convicts him of having drug money, which he gets from the drug trade. So they're very problematic to deal with that. The real problem with this is, Jim and Tammy Brown, a teacher and homemaker or whatever, why wouldn't they sue you for defamation, right? So you put on your, how do I defend this cap and be kind of rigorous about it. And posing allegations as questions is something that news outlets love to do, but if the clear intent is they are involved in the son gangster's lifestyle, nobody's asking these questions except for News 1130. And the neighbors. And one neighbor. Is there a News 1130 person here? Or? Great, so we're not defaming you with this text.
That's good aggressive reporting.
So, I would talk to the editor or the producer or the reporter and say, okay, well, this neighbor, you only found one, you know, have you got a number of neighbors that are all saying the whole neighborhood is scared to death? Are you going to be able to justify that the whole neighborhood is scared to death, or are you really going to be able to justify some parents? And if you can only justify some parents, maybe you should only go with some parents. You know, well, take your story as far as your proof will go based on ideally 2 or more verifiable sources that you know don't have an axe to grind, like the neighbor that hates them for, you know, chopping down their trees or infringing their fence or whatever. So you've got to check your sources, you've got to get your language close. But then if you were comfortable with the one or a couple of neighbors, I think the scared to run their kids' play you could work with and justify it based on, you know, you found a number of parents that are scared, or it's a comment based on the fact that these people have been charged with terrible crimes and they're often there and they have young kids. Maybe you'd be okay with the first quote. Sorry, there's a couple of quick questions.
Sure, yeah. Let's move this forward in time. Imagine that Tony's been convicted of running a drug dealing gang or whatever the charge would end up being. Would we be able to say at the end, how do you, I'm guessing it's their son's drug money? There's no contempt issue at that point, I guess?
Yeah, so then on the defamation side, I mean, you know, used JAGs are pretty affordable, you know, $3,000 or $4,000 in the province classifieds. I don't know if that's expensive, but you know, you're taking a side swipe with these parents without any basis, right? I mean, if you had to prove that that the parents were receiving drug funds, could you show anything like it? Probably not, right? So what are you going to rely on? Responsible journalism? Well, I don't think so. This isn't a very important story, is it, really? So what have you got? Fair comment. Now, is it fair for this neighbor to make that assumption based on it? Maybe you could have that as an argument, but I wouldn't want to defend you on that. I think you'd go down. So, so I think you've got a big problem with the second paragraph on a bunch of bases. On the first paragraph, you could probably work with it and tell it in a, you know, in a manageably risky way.
Yeah, but I think I agree with you, Mike. I mean, that even after conviction, saying unless you got genuine proof of it, I'm guessing it's the son's drug money that paid for their car. I mean, that implicates them into the crime. There's another question in front.
Yeah. Really quick, is there a problem with printing exact addresses in certain cases, like in the photo caption there, or linking to specific places on maps?
Good picking up of detail, because I get into that question quite often. It's, so can I show the actual house, show the actual address? I mean, there are times, not this example, but there are times when a publication ban on the identity of, say, a young offender puts a limit on that. But there's also times where, this might not be the most obvious example of it, but there are times when I think running somebody's specific address really puts you into a possible, I would call it a negligent situation. I mean, what happens, you know, like let's you've changed the facts a bit and you've shown the house and given the address of somebody accused of being a serial pedophile. And what happens when some guys get liquored up and get in the back of their pickup truck and decide to go teach this guy a lesson? And you've just given them the where to go, right? So I tend to, on those situations, back off. I say, you know, you might show some somewhat generic visual, you know, that kind of illustrates a residence without saying, making it that obvious. In this particular case, I don't know. I don't think there's a danger to them. I mean, I wouldn't think somebody would go and commit revenge on them over this particular issue. But you do need to think that pretty carefully. We
had an example where there was a case in Ottawa of a man who he was accused of abusing his son, I believe, as opposed to stepson. Mm-hmm. And our legal advice said it's a child, you can't identify the house. You can shoot the house very tightly so you cannot tell. It could be any window, anywhere, steps, that kind of thing. And the neighbor who said, yeah, the kid ran through my yard. I had no idea he was looking for water 2 days ago. We blurred the neighbor. Our competitor that night, I saw the house, 1224, whatever it was. The neighbor, not blurred, totally. So, you know, he got different legal opinion. Ours was that if you identify the neighbor, you could identify the house. Therefore, you can identify the child, and so. But that's. Well,
I think when it's a publication ban to protect the identity of, especially a child,
I mean, I felt comfortable going our way.
Yeah,
but
a judge is not going to. A judge is
fine.
not going to err on the side of aggression. There, a judge is going to err on the side of protecting that kid. Yeah. Right. No, that's going to be clear. Okay. I think we have time for one more before we need to move to the next slide.
You're mentioning the fact that this guy is a teacher and he's got gang members in his backyard drinking. That's not a problem reporting that?
Oh, I think it potentially could be. I think that's Mike was saying, that you've got defamation of the people potentially, unless you can prove that that's the case. Bring in the drone helicopter. I'm just kidding. But you'd need to be sure. I mean, if it's true, they're back there and you got multiple neighbors who can say, yeah, they're there every Friday night and they're drinking. You can smell the pot and they're all wearing their jackets and they all show up in their motorcycles and swagger in. Then if it's true, that's a complete defense on the defamation side.
If you did run the address of, say, a convicted gay basher and someone took matters into their own hands, would you be legally liable or just face a moral question?
I think there's potential for both. I mean, the right set of circumstances. We came close to having a court decision on an issue like that a number of years ago. I think in the right set of circumstances, the question in law is it foreseeable that you could cause harm to somebody through your actions, and you did? I think you could construct a scenario where it's pretty foreseeable. Okay. Now we're now going to move forward a little bit to the run-up towards trial, and just get Ben to give you sort of a bit of the legal background about what happens in the run-up to trial with something called voir dire, and then a couple of things that follow that.
All right, so the run-up to the trial. During preliminary hearing and hearings on admissibility of evidence, voir dire, the judge ruled anonymous telephone threats to the police officer who was gunned down are inadmissible. The ban on voir dire lasts until the, quote, jury retires to consider its verdict or the trial is over. Other bans from bail and preliminary hearings last until, quote, the trial has ended.
Okay, so there's some basics as far as knowing how those, what we call the voir dire ban and the preliminary and bail hearing bans work. And when you get towards the end of things, you need to think about, well, when does this end? When can I report some of this juicy stuff that I haven't been able to before? And then we get a development. Maybe read that one too.
So on the 5th, the Canadian Press runs a story under the headline, Venturi pleads guilty. In a surprise move today during pretrial evidence motions, the co-accused in the Tony Brown murder case announced a guilty plea to the lesser charge of criminal negligence causing death. Crown has stayed all other charges. Observers speculate that the co-accused, Arnold Venturi, is cooperating with police.
Okay, so you got one of two accused who's now pled out. I guess their trial's over. Does that put you in a different position, Mike? Is there any problem?
No, Wendy.
Excellent Canadian Press reporting.
You know, I'd like to hear others' thoughts about this, but I'm inclined to think it's okay. The fact that Venturi has pleaded guilty, in my mind, and I think I'd be fairly comfortable arguing this in front of a judge, doesn't say that Brown is guilty of anything. And the fact that he's cooperating with police, I don't see anything in here that is going to sink you for sure. I think my advice probably would be, why don't you add a motherhood statement or parenthood statement or whatever at the end to say, let's be absolutely clear that, Tony Brown has not been convicted of anything and he gets his day in court and all the rest of it, to give your lawyer something else to argue with, or to make it less likely that the Crown would take a run at you for whatever reason. So I'm okay with this, but I would suggest a little bit more dressing to make it even more defensible.
Okay, well, let's make it a bit more interesting then. On the heels of Venturi turning rat, we've got a tweet coming out from the Globe and Mail here.
Live from the court, Brown pleads guilty, second-degree murder, sentencing June 1, plea deal after judge ruled incriminating texts from Brown are inadmissible.
So a couple of issues that arise. One of them is...
Brown pleading guilty or Venturi?
Yeah, so Venturi had pled guilty in the previous. Now we're a couple days later, and on the heels of knowing that his buddy has gone state's evidence, I'm speculating, Brown pleads guilty too, or at least enters a plea deal, second degree. But the sentencing is still coming up June 1. So, question for Mike or anybody is that ban that goes until the trial has ended still in effect? Because they're including in it some plea deal ruled after judge ruled inadmissible texts or incriminating texts inadmissible. So you've got some stuff from preliminary and from voir dire being reported prior to sentencing. What do you think, Mike?
Well, I mean, your three possibilities are, you know, when the verdict comes down, the trial is over because guilt and innocence has been established, right? Your second possibility is after sentencing, and I guess your third is the appeal period at the end of it all. Now, my advice to my clients is, you know, 648 sets up a contempt, and that's a very serious allegation. You read it strictly to the benefit of the people. So the words say trial has ended. I think trial has ended is when you get a verdict. I think the tweet is fine so long as they're complying and they're an accredited journalist to tweet out of their courtroom. But I think they're fine once the trial has ended. And some Crown may try and argue with you, no, you got to wait till sentencing. I think they're wrong. That would be my advice.
Well, there was a case a few months ago where Crown were phoning reporters in town, if I recall correctly, and saying, why are you reporting this voir dire stuff? The sentencing hasn't occurred. What was that case? What was the case, Wendy?
Oh, you're just going to set me off. It was the case involving the gang rape. You took notes on it, remember? And it
we are terrible.
Yeah, no, it was. That's right. It was the Laura Sendry case. She's got it right. It was the Laura Sendry case. It was the Laura Sendry case, and the cops were phoning around and telling us that the information that came out in the prelim with the Mr. Big Sting and the whole bit was banned from publication until sentencing. And we didn't go with the story, and others did, and I spent 2 months in a fit of retribution, phoning the cops, demanding to know when they were going to charge the ones that went with it, with contempt. And the guy finally got ticked off with me and told me that that wasn't up to him, that the charge would be up to the Crown. His name was Kieran Feenan. Yeah.
And his address? I'm
But my question actually goes to all of this, and Dan will know why. So is there any precedent on when a case is finished? Has there been a ruling on when a case is finished?
Well, the trial has ended. There's some Ontario law on this when there's a verdict.
But my memory of it is in Shafia, and I think not Russell Williams.
Shafia's the one you meant.
Yeah.
The same scenario.
But it goes to the jury's sequestered. And I could be wrong, but my memory of it is as soon as it's sequestered jury, everyone says, here's what the jury didn't hear. They didn't hear that they'd actually killed 10 people before this or whatever. And the argument we've received in the past is the jury's sequestered, it will not affect their decision. And therefore, the trial will have ended effectively. So that when they come back, they will say, they will rule. Now, I'm going by memory, I should have checked, but that's my memory is once they're sequestered, as long as you're sure that they cannot hear this.
Well, I'm going to assert that the situation is like this. If the case actually goes along and nobody pleads guilty and it goes to the jury, when the jury goes out, the voir dire is reportable. Yeah. The previous prelim bans require the trial to be over, so they require a verdict. So if you want to go way back to those things, if the case ends early because of a guilty plea, for example, then the question is, when's the trial over? And there actually is law, Supreme Court of Canada law, not that goes to it's not about a publication ban, it's about a different context, but saying a proceeding is over with verdict, sentencing is a separate proceeding. And so we stood our ground on that example that you gave, Wendy, and we never heard a peep from them, even though they were rattling their sabers back at the time.
When it goes to sentencing, there's no longer a jury, so isn't contempt
Exactly.
like a non-issue for releasing information that the judge would have heard themselves anyway?
I think that's right, and so it's not like the purpose of a ban is to prevent jury influence. So if you look at it in those terms, that supports is another reason why you'd think the end of trial must mean verdict.
Yeah, you can't prejudice a jury that's not there anymore.
What if Tony Brown was on a BC ferry and this happened? So we were covering the Queen of the North trial, and we had a couple of things with this whole issue. One of them was, and we dealt with you on this, there was this TSB report that was already public, and as soon as the jury had retired, we had a story just comparing what the report said with what the testimony in the trial, and our thought was, again, the contempt issue had sort of evaporated in that case because the jury was sequestered. There was some concern as to how sequestered was the jury, and the judge wagged her finger, and we ended up taking the story down in some places. So is there any thoughts on whether that has changed when there's some concern about whether sequestration is as tight as it is?
Well, two interesting things about Queen of the North. I'll weigh in on that one. The one to be aware of is, in that case, the judge, this thing that you can report voir dire once the jury's out, the judge made a special ruling in that case, extending that to verdict. And then sometimes in big cases, Shannon Murn was another one, they'll do that. So you need to be live to that possibility.
And of course, this part wasn't.
No, I understand that. But the second point is, even though, because it was from preliminary and the jury was not going to hear this stuff.
The jury heard that was the thing that drove me crazy about that. The jury heard nothing about the TSB report.
Right.
There was no ban on the TSB report. It didn't come up in prelim. It didn't come up in voir dire.
Well,
she pitched a fit about it, but there was no.
Well, the judge did pitch a fit about it, and the judge pitched it because she had specifically ruled. I think ultimately, I would have disagreed with her, but she had specifically ruled that the jury is not to hear that this guy was a pothead, right? That's what it was. The marijuana stuff in the TSB report was stuff that she had specifically ruled against, and then she was made it quite clear in court that she was quite concerned to have seen stories appearing that quoted that part of the TSB report, saying that I already ruled against that. And even though there is pretty clear law that once a jury is sequestered, they shouldn't be receiving any of that, and it's not the media's fault if they do. One of the concerns I raised and sort of mused about at that time is, in this era of everybody carrying an iPhone and all of that, would a judge say, no, the possibility of leakage into the jury room is just too great to permit that sort of thing? I don't know. I think the judge had made such a clear view that I don't think anybody wanted to be the test case and fight that issue and win it, but win it $30,000 later. So that I think was kind of the practical answer to that case.
Oh, we got a question.
Just for Michael and Dan, is there any instance in Canadian criminal court proceedings where a jury would be involved in sentencing or in any discretion around sentence?
No, never. I have a couple last things.
Let's get one or two more questions.
Can I just make one brief point while we get to the next questioner? And that would be, this may be obvious, but where the criminal proceeding is outside of BC, like somebody who's arrested in Washington State, contempt's not a problem. You can report on whatever you want. You can be as inflammatory as you want and publish pretty much anything. You got to worry about defamation.
They do the reverse too.
But sometimes people call and say, "Oh, can I say this?" And you say, "Well, why not? Why not? How about some more? What about this quote?" Online, they're saying way worse things. You should look around. So.
Good old Burns and Raffe.
Yeah.
What if the accused elects judge alone? Are all these bans out the window?
Very good point. If accused elects judge alone, the voir dire ban doesn't apply. If the accused elects judge alone, the previous bans on the bail hearing and the preliminary are still in force. We actually fought a Supreme Court of Canada case saying it's ridiculous to have the bail hearing ban continue even when the jury elects judge alone, and the court actually ruled against us, saying, no, we're going to uphold that ban regardless, because at the time of bail, it's such a uncertain period, and anyways, there was all kinds of reasons that 9 judges agreed to, and I wasn't one of them. So, anyway, so the bans earlier on stay in force, but when there's no voir dire, when the voir dire is in front of the same judge, they're hearing the stuff anyways, so there's no ban. And the actual word of the code is when the jury any information when the jury is not in the room cannot be reported. So by definition, if there's no jury to be out of the room, that ban evaporates.
Mike?
Yep. Are all juries sequestered still?
Yes. The criminal code requires that when they are retired to consider the verdict, they are automatically sequestered.
That's everything. So thank you, everybody, for coming out. And again,